Hey everybody, welcome back to SEC Roundup. I'm Nick Morgan, founder of ICANN, the Investor Choice Advocates Network, and co-host of SEC Roundup. Our other co-host, Tom Zucchero, can't join us today, but we are pleased to be joined by two attorneys from Quinn Emanuel, Sarah Concannon and Kurt Wolfe. Thank you both for joining us. Sarah, for those who want to go look up her bio, was a member of the executive staff of the SEC, senior trial counsel, counsel to two of the co-directors of enforcement. Kurt, many of you will know, is of counsel in the Quinn Emanuel SEC defense practice and also co-host of the inSecurities podcast. So thank you both for joining. We're here to talk about an incident that actually started a few months ago and then sort of resurfaced this month at the SEC, having to do with the SEC's administrative proceedings and some sort of strange errors that happened with regard to some adjudication memos. So, Sarah, if you can, why don't we go back to what happened in April to sort of set the stage, and then maybe Kurt can bring us up to speed with what happened more recently.
Sure, and it's more than a few months. Time flies when you're conducting an internal investigation, but it actually dates back to April of 2022, when the SEC announced through a statement that they had discovered that there was an issue with what they called a control deficiency between the enforcement arm of the SEC and the adjudications arm. So, as your listeners are likely aware, the SEC, like many administrative agencies, has an in-house court. And the issue here is that they uncovered that in connection with two pending administrative cases, which at that point in time were in the district courts, that there had been downloading by administrative staff on the enforcement side of the memos that were going to the commission from their staff on the adjudication side. So I think, Nick, as you commented at the time, this is essentially like the prosecutor having access to the law clerk's memos. So, it struck us all at the time, like, this begs some questions about what are the internal processes at the SEC. The firewalls that exist between the right hand and the left hand are supposed to be completely sacrosanct. They are built into the Administrative Procedures Act. And it is important so that the enforcement process is not tainted by what the commission may be contemplating on their potential actions and vice versa. And so those walls are supposed to exist. They're supposed to be separate. But at the time the SEC announced this, it did it in a very, we're going to conduct an internal investigation, but what we've determined is that this is two isolated cases, that the information that was accessed did not impact anything to do with the overall adjudication of the case, and largely limited to administrative staff essentially downloading memos and uploading them to a database that they shouldn't have been uploaded to. What came to a head in early June is that the problem is much broader than what the SEC had initially announced and actually permeated far more cases than just the two that they had initially identified. And that led to a second statement by the commission on basically the first week of June, in which they walked through their internal investigation and did some mea culpas, but also some things that raised some questions that Kurt's going to speak to.
Yeah, certainly in light of the way it was characterized back in April of 2022, what came out this month in 2023 was surprising. So, Kurt, what did happen? What was the June statement about?
Yeah, so we had this quiet period, right, where nobody really knew what was going on. At least according to the SEC, members of the SEC's own exam staff were running around and investigating this issue to try to bottom it out, which is an interesting side note that they were sort of handling this in-house. But on June 2nd, so just a few weeks ago, the commission released, as you said, a second statement that provided some additional details about the two matters that were discussed in the April statement, as well as findings regarding two more buckets of memos that were inappropriately accessed by the enforcement staff. The first bucket included, in addition to the two from last April, 28 more matters pending before the commission in which the enforcement administrative staff accessed adjudication memos. The second bucket included 61 additional matters in which the staff accessed one or more adjudication memos that were broadly applicable to numerous pending matters before the commission. So in total, we're now looking at over 100 cases in which the enforcement staff, the prosecutors, as I think Sarah described them, had access to the judge's memos. Now, in the June statement, the commission said that it deeply regretted that the agency's internal systems lacked sufficient safeguards surrounding access to the adjudication memos. I have to say I appreciate the sentiment, of course, but I think the June release really made clear that this problem was much bigger, much more widespread than we understood before. So part of me thinks maybe the deep regrets are coming a little bit too late in the process.
Yeah, well, that's interesting. And deep regrets are by their nature backward looking. So one of the questions that both of these comments from the SEC have given rise to is what do we do now? Why does this matter? Sarah, what do you think? This is this something that we just problem solved and we move on, or are there other issues here?
Yeah, no, definitely not problem solved and we moved on. I mean, first of all, there's kind of an irony here of the SEC, which is an agency that's charged with internal controls investigations and frequently brings actions. I think there was a recent $15 million action for internal controls violations, somehow is failing to keep its own house clean. But there's also an interesting juxtaposition here between kind of when the SEC goes out with great fanfare, tweets out in a press release that they've just brought in an enforcement action and they get 5 million plus hits, versus what they did here, which is they issued this statement on a Friday afternoon with the entire justification that Kurt has just described. We conducted this robust investigation. Here's what we determined. Separately, in a different part of the SEC's website, what they announced is that because of this breach that they've now identified, they have dismissed 42 pending cases that were impacted by improper access. And what they said in connection with that is, although they had determined that there was no misuse of the information after their internal investigation, that they were nevertheless going to dismiss these 42 actions because of the control investigation or control violation, and quote, that they were taking this action to protect the commission's resources. This feels a little bit pretextual, potentially. Two of these actions, Jarchese and Cochran, which we've mentioned, were already raising Supreme Court challenges successfully to the existence of the SEC's administrative courts. The fact that they now have disclosed an enormous internal controls violation gives rise to questions about, is it appropriate for the administrative courts to exist? Are they able to adequately protect information? And so this almost very quiet dismissal of 42 actions that were pending seems to be a little bit of CYA and a little less about protecting the resources of the commission, unless what they mean is protecting the resources of the commission against many, many constitutional challenges built on this type of information. The other piece of this is, many of these cases were very old, had been pending for many, many years. In fact, since Lucia, the SEC has been litigating less and less in its administrative courts because of these types of challenges. So what this means is these are cases that had been tried once, in some instances twice. Relief had been ordered. They were up on appeal to the commission. And so the other thing that they had done in connection with many of these cases, I think it's 48, where there had been requests by individuals to vacate appearing and practicing bars. So the associational bars that say, because I've violated the federal securities laws, I can no longer act as an officer or director of an issuer, et cetera. Those were vacated as well. So Yeah, I'm gonna take off my defense hat and hand it over to Kurt to talk about the implications from an SEC perspective of what it means for that relief to no longer be in place.
Let me, before we do that, just a couple of thoughts, Sarah, because what you said I found really interesting. So the two cases, Jarkizi and Cochran, that you mentioned, I noticed that the SEC did dismiss the outstanding action against Michelle Cochran, which, they had lost the Supreme Court in a unanimous decision in that case. I don't believe they dismissed the Jarkizi case. The government has asked the Supreme Court to review a loss in the Fifth Circuit. Jarkizi, of course, raises some of the issues about separation of powers that may have given rise to this problem in the first place, where you've got the judge and the prosecutor sitting under one roof. So I think it's interesting that that Supreme Court case, if the Supreme Court agrees to hear it, still remains to be heard, and maybe the remediation will come from the Supreme Court rather than from the SEC. But the other point you raised was the limited number of actions that the SEC currently uses its administrative process to litigate. And one of those areas is actions against regulated entities like investment advisors and broker dealers. So Kurt, maybe you can tell us, like, if I'm a regulated entity, should I care about this issue going forward? Do I have a concern here? Or what are your thoughts on sort of looking forward from the reports?
Yeah, I mean, maybe not, probably not, right? In the sense that hopefully they're cleaning this up. I think this is a disaster for the SEC, if I'm being honest, right? Sometimes I'm an apologist for the SEC. To the extent that they were transparent about this, I think that's a good thing, but it's not good beyond that for a few reasons. One is, I think if you get at the SEC's mandate, right, what's first on the list? Retail investor protection. And it doesn't matter who the chair is. It doesn't matter who's in the White House. All of the director of enforcement speeches, all of the chair's speeches are going to talk about protecting retail investors time and again. Here we have 42 cases where, the SEC determined, or at least made an initial determination, that somebody had done something wrong. A lot of these are fraud cases. A lot of these are cases where there were hundreds of thousands of dollars in disgorgement that was supposed to flow back to harmed investors. And that's just out the window. So I think that's a really bad look for the SEC, and it's bad for the investors who are maybe harmed by some folks who are bad actors in the industry. That's the second reason I think this is bad. I mean, we represent investment advisors and broker dealers. We do a lot of work, in FINRA cases, but I think when you talk to folks across the industry, they'll say things like, if there are bad apples, yeah, let's get them out. Let's get them barred. They make us all look bad. They sort of cause the public to have less trust in the advice that they're getting from people with, financial advisory credentials. And so here you've got a situation where some of these folks may be coming back into the industry, or at least it looks like the cop on the beat isn't doing their job. And again, that's not great for, Mr. and Mrs. 401k. I think Elise Walter used to talk about, her aunt and uncle who didn't understand the investing industry, right? But those are the people we should be thinking about. And every time you get a case like this, I think it just sort of further undermines the credibility of the staff in doing its job, setting aside whether or not we think ALJs are constitutional. Just in terms of the outcome of these matters, I think that it's significant.
Yeah, no, that's a great point, Kurt. Well, thank you, Kurt. Thank you, Sarah. We really appreciate you coming on SEC Roundup. And so we'll keep an eye on this issue, see if there's any more fallout. Maybe there will be another statement by the commission later, but hopefully this is at least the end of this particular scandal. So everybody else, please tune in for the next SEC Roundup. And until then, goodbye.